Ladies and gentlemen, Namaskar and a very good morning to you all. On behalf of Dr.M.G.R Educational and Research Institute, I am Mrs. S. Santan Lakshmi, Assistant Professor, Department of Information Technology, delighted to welcome all to this virtual faculty development program on intellectual property rights and patents. We are thrilled to witness such enthusiastic participants gather to deepen their understanding of this significant topic. It's my pleasure to invite Dr. N. Kanya, Professor, Head of Department of Information Technology, Additional Dean ENT, to deliver the welcome address. No, ma'am.
Dr.M.G.R. Respected dignitaries, esteemed guests, and dear participants, we are happy to welcome our Vice Chancellor, Dr. Geeta Lakshmi ma'am, and the speaker of the session, Dr. T. Pavan Kumar, Senior Scientist, CSIR, IMMT, Bhubaneswar. The Department of IT happy to inaugurate a 5-day FDP on Virtual Faculty Development Program on intellectual property rights and patents. We are having 5 days events, or we are having a list of speakers from CSIR for all these 5 days event. Hopefully it will be helpful for all the researchers and faculty members who are intend to publish their work, and they are in the research field to get the work promoted, and they want to publish their patents. It will be really an eye-opener and helpful for them. All the speakers are from CSIR. Day one, we are having Dr. T. Pavan Kumar sir. He is going to deliver a lecture on innovation and IPR for academic and research. Day two, we are having Dr. Kapil Arya. He's a senior principal. He's a principal scientist, CSIR, IPU New Delhi. He's going to deliver a lecture on IPR overview, essentials of copyrights and trademark. On day three, we are having Dr. Yogesh Dobel. He's a senior principal scientist, CSIR, IPU New Delhi. He's going to deliver a lecture on essentials of patents and industrial design. Day four, we are having Dr. Lipika and Patnaik. She's a senior principal scientist, CSIR, IPU New Delhi. She's going to deliver a lecture on patent filing and preclusion. Day 5, we are having Dr. T. Pavan Kumar again. Here he's going to deliver a lecture on patent claims, trends, and execute hands-on exercises on day 5. Welcome you all. I'm happy to welcome all the speakers for all the 5 days on behalf of Department of Information Technology. Today, we are having this 5-day FDP with overwhelming response from the participants. We got around 1,500 registration throughout the country. Happy to welcome all the participants. Kindly be online throughout the session. Be interactive. You can post your questions through the chat box. We are happy to serve. Try to forward all your questions to the speakers, and kindly maintain the virtual ethics throughout the session. I'm happy to say my gratitude to our founder chancellor, Dr. A.C. Shanmugam sir, and our president engineer A.C. Arun Kumar sir, who always motivates us to reach the heights, various heights. I'm happy to thank the coordinators of this event, Professor Madhura and Professor Sir Vishwapriya, and the team IT, without whose support this would not be happen. And thank them for their tireless effort to make this event execute. Once again, I welcome you all for this event. Thank you.
Thank you so much, Dr. N. Kanya, for your inspiring and insightful welcome address. Your words have truly set the stage for a positive and engaging faculty development program on intellectual property rights and patents. Now, I would like to call Professor Dr. Geeta Lakshmi, Vice Chancellor, who had been instrumental to the organization's journey. We are indeed fortunate to have her with us today to share her insights and experience.
For this FDP program, 5 days FDP program on IPR and patents. In fact, it is one of the subjects which is very important for a university or any institution. So I welcome on behalf of the management. We should thank our chairman A.C. Shanmugam and our president A.C.S. Arun Kumar for making this possible for the FDP program for the 5 days for the faculty. And I welcome Mr. Pavan Kumar, who is there from Bhubaneswar, to give his insights and his experience and how to go about this intellectual property rights and the patent, what are the different ways and means of making it possible. In fact, I see many of the innovators or the researchers and I'm really before I could start, I should thank the Department of IT with the HOD Kanya and team for making this possible, and so that many of the faculty would benefit out of it. And of course, I should thank Pavan Kumar, who is really an experienced person, to come and share his views and what to do and what not to do when you are filing a patent and the intellectual property rights. So it would be meaningful for the faculty to learn rather than to listen and just forget. I want them to learn. So in for that, I want the pre-feedback, I mean the pre-enrollment, how many of the professors or the faculty have enrolled, and the post-feedback for of this FDP program. And I think so Kanya would make it possible on the pre and post feedback of the faculty, and so that it would give us the analysis of where we stand and how to go for in future to get these patents and the IPR. So on this way, I want Kanya and her team to get the feedback for this, and I think this FDP program would benefit our faculty, and it's 5 days, and I think so Pavan Kumar and his team, the other five, would give assignments so that they would know like where they stand and what to do in future. Thank you and one and all for making it possible. Thank you Kanya and all the speakers for coming and giving us their insights. Thank you.
Thank you so much, ma'am, for that enlightening and inspiring address. Your words have indeed set a perfect tone for this program, and we will sure that we will give the feedback for this program. Before we proceed with the Chief Guest address, I would like to invite Mrs. D. Madhura, Assistant Professor in the Department of IT and Coordinator of this event, to introduce our esteemed Chief Guest. She has been an integral part of our faculty and brings a wealth of knowledge and enthusiasm to our department. Very good morning, everyone. Very good morning, everyone. It is my distinct honor and privilege to introduce our esteemed chief guest, Dr. Pavan Kumar, Senior Scientist, CSIR, Bhubaneswar, as a chief guest for today's event. Dr. Pavan Kumar stands as a beacon of excellence in the realms of chemistry, intellectual property rights, and academics. With a multifaceted career spanning research, education, and strategic leadership, Dr. Pavan Kumar embodies the spirit of innovation and dedication for scientific advancement. Currently serving as a senior scientist at the prestigious CSIR Institute of Minerals and Biotechnology in Indonesia. Dr. Pavan Kumar's contributions extend far beyond the laboratories. As the coordinator and convener of intellectual property and business development initiatives, he plays a pivotal role in shaping the direction of cutting-edge research and fostering partnerships for technological innovation. In addition to his scientific pursuits, he is deeply committed for ethical practices, serving as the ethics officer and secretary of the Standing Ethics Committee. His dedication to upholding the highest standards of integrity underscores his role as a leader not only in scientific endeavors but also in ethical governance. As a distinguished faculty member of the Academy of Scientific and Industrial Research, he shares his wealth of knowledge and experience with the next generation of scientific minds, inspiring and mentoring aspiring researchers. With a stellar academic background, including a PhD in synthetic organic chemistry from CSIR IICT Hyderabad and extensive postdoctoral experience, his expertise is widely recognized and respected. His accolades, including prestigious awards such as the Wipro IP Scholarship and recognition as a Telagan Young Scientist, testify to his outstanding contributions to the field. Beyond his professional achievements, he is deeply engaged in collaborative efforts, serving on various committees and steering groups aimed at fostering interdisciplinary cooperation and innovation. It is with great admiration and anticipation that we welcome Dr. T. Pavan Kumar as our chief guest today. Thank you. Thank you so much, Mrs. D. Madhura, for that wonderful introduction. Uh, Few guidelines for the participants. Please mute your mic. Filling the feedback for all 5 days is mandatory for certification. Participants, please post your queries in the comment box. It will be answered during the question answer session. As we embark on this journey of exploration and learning, we eagerly anticipate our chief guest, Dr. T. Pavan Kumar, Senior Scientist, CSIR IMMT, Bhubaneswar, for his valuable insights and wisdoms on the topic of innovation and IPR. Your presence here today not only enriches our program but also inspires us to strive for excellence in our academic pursuits. Welcome, sir.
Thank you. Thank you very much, and very good morning to all the organizers as well as the participants present in this virtual faculty development program. First of all, I really appreciate the efforts taken by Dr.M.G.R. University, deemed to be university, in conducting such an important program, especially for the faculties. We keep seeing programs of this kind, which are for the general audience and or majorly for the students. But however, an exclusive program for the faculties is really a great appreciation for you all. And in this regard, I personally thank Dr. Kanya in connecting me to this program. Not only me, even my entire team. And when I got a request to suggest the speakers, I thought of, instead of suggesting people from other sectors, better it would be more helpful for the faculties if I can connect a scientist from CSR, because CSR is a very well organized R&D agency in the country, which has got a systematic practice of IPR. So therefore, all throughout these 5 days, myself and my friends from different parts of CSR labs will be engaged with you in covering almost all basic aspects of IPR. So with this, once again, I really appreciate the efforts of M.G.R. University, and in particular Dr. Kanya, head of the department, and also Dr. Vishwapriya and Dr. Madhura. And now I don't know your name, but for you also, like those whom I am seeing and talking to each other. So I really appreciate the efforts. And getting 1,500 registrations is not a simple thing. I think I really appreciate the entire organizing team for reaching out to the maximum number of people. Maybe your information might have reached to some thousands, so that you could get around 1,500 participations. Any program on IPR with 1,500 registrations is not a small program. I really once again appreciate you all. So with this, I just going to my session. Being the very first session, I thought of talking to you today on the aspect of innovation and IPR for academics and research. In this
Thank you,
session,
sir. Sorry for interrupting. Do you have any PPT for
yes,
this
yes,
session?
I have PPT.
Okay,
So
sir.
I think I have to share it from this present tab, right? Is it so?
1 second, sir.
There is
Doesn't have.
a. I'm trying to share. If share screen, I don't know what to do. Share screen at least
Hello.
to monitor.
Hello, sir. Can you present your PPT?
Yes, yes. How to present? Should I go on to the present tab here and present the
Yes,
PPT?
yes, yes, sir.
Okay, I'm doing that. I'm doing that. And again, when I click on the present tab, there are
Mm-hmm.
slides, video file, and share screen. Which one should I use? Share screen or slides?
Share screen. You can do
Share
share
screen.
screen,
Okay. Screen sharing works best on a good computer. Okay.
or even slides should be. If you share the
No,
slide is also that will also.
I think no. I think I have come to the share screen. So I'm just sharing. I'm just sharing the screen. Hopefully that you should find it better. Is it okay now? Is my screen
Yes,
shared?
yes, sir. It's loading. Yes.
Okay.
Yeah, yeah. Yes, sir.
Yes.
Yeah, we can see
And
the
both
first
slides are moving,
slides.
right? Okay. Okay.
Yeah.
So
Yes,
very good morning.
moving.
Okay.
Yeah.
As
Thank
I
you, sir.
mentioned, I will be talking to you on innovation and intellectual property rights for academics and research. And before I move further, these are the places from where I got my education and working experience, both in terms of chemistry research as well as intellectual property. Of course, Dr. Madhura has given me a detailed introduction, but however, I just thought of showing these affiliations. And here is the outcome. Because majority of you present here are faculties, please look on to the right hand part of the slide. It talks about the patents, technology transfers, and licensing. All this we could do only because of integrating our learnings on IP, especially the patents, with respect to day-to-day research activities. Until 2015, I was only having the left-hand side part to showcase. But since 2016 onwards, we could able to incorporate the right-hand side part. By now, we could able to file more than 40 patents. And luckily, 4 of 4 patents got licensed to Sun Pharma. With all this background, now I will be talking to you on these subheadings. I'll give a very quick overview on IPR. Of course, tomorrow my friend Dr. Kapil Arya would be talking to you more on the overview and different types. And then I'll show you some examples related to inventions and the impact of IP. And we'll discuss why IP is really important for us. What are the factors? What are the statistics at global as well as national levels? And then I'll show in what way patents are very, very important for the researchers like us, some strategies, some examples to inspire us further, and we try to end up our session with some takeaway messages. So this would be the broad overview, a broad layout. See, please look into this slide. And try to tell me, do you find any difference? Of course, you can put your answers in the chat box. Both are paracetamol here. The purpose for which we use paracetamol would be one and the same. But do you find any difference here? I don't know whether your answer is yes or no, but keep that for some time and we'll come back to this slide with the answers at a later stage. But keep this in your mind. Then coming to IPR. IPR, in my opinion, is a subject which has got relevance to each and everyone. Less educated, more educated, highly educated, not educated, overeducated, whatever it may be. Even illiterates also, purely illiterates. Even for them, it is relevant because it is a subject which has got association with each and every activity that we come across in our day-to-day life. Irrespective of the domain, irrespective of the discipline, irrespective of the designation, irrespective of the position, it is relevant. We call it as a property. Yes, because once we create something, we have to protect. Through that protection, we get the rights. And it's a property, unlike any other properties, which can also be exploited further. As a property, it can be sold, it can be bought, it can be leased or rented, it can pass under will, it can also be assigned. If you have a bungalow, if you have an estate, if you have a car, or if you have others, because it is yours, you have all the right over it. But however, in traditional properties, your property or your right can be transferred to generations after generation as long as you or they can hold. But intellectual property is not like that. It is a limited time enjoyment right. Intellectual property rights are limited time enjoyment rights. So this is the major limitation. So therefore, except for the time limitation, all other benefits that you get from this property are similar to that of any other properties. And here is the classification. Please see this chart carefully. Please see this chart very carefully. Broadly, IP is classified into two major types, copyright and industrial property. Copyright includes rights of the author and rights of the performer, whereas industrial property again depends on two factors. One is information, the other one is innovation. Patents, trade secrets, and industrial designs goes under innovation, whereas trademarks and geographical indications, they fall under information category. On the left hand side, I tried to show you the different types of IPs with an example each, starting from Darjeeling tea for geographical indication, then Mercedes Benz, or even the kind of platform that we are using today might be having some kind of identity. And even M.G.R. University, Dr.M.G.R. University, your university has a logo or emblem that itself is a trademark, which is a reflection of the quality and identity of your organization. And trade secret, the composition of Coca-Cola is a secret since 1886. And copyright is an example is Harry Potter, written by J.K. Rowling. And the technical aspects of the mobile phone that we see today or use today, they go under patents. And the design or the body of the mobile phone is again covered under industrial design. So likewise, these are the different types of IPs. And then now we look into how the different types of IPs can be evolved or attested to the creations that we do. Believe me or not, the strategy or the approach is very, very simple. It is the idea which serves as the source of any kind of IP that we see today. because it has to start from here. And once a thought comes or an idea comes here, you should start working on that idea. Upon working on that idea, if you can see a resultant outcome which is in a physical form, this resultant outcome should be in a physical form. Depending on the nature of this resultant outcome, you may get any kind of IPs that are mentioned here. So if you have an idea, if it results into a work which is expressive in nature, like novel, poem, music, compositions, choreography, painting, arts, cartoons, whatever it may be, if the works are expressive in nature, then you may get a copyright. An idea, if it results into invention or innovation, then you may get a patent. An idea, if it reflects the quality and identity of a product or of a service, then you may be getting a trademark. Idea resulting into appearance. When I say appearance, only the aesthetic part, that can be covered under industrial design. And idea, keep it secret, don't disclose to anyone, do some trade, and preferably make some profits. It may be a trade secret. So again here, the different types of IPs evolving from ideas were shown with some examples. So this is a simple flowchart, and depending upon the product or the creation that you do, you need to characterize it. You need to assess whether this falls under copyright or a patent or a trademark or a design or a trade secret. Accordingly, you can obtain those respective IPs. I mentioned that intellectual property rights are limited time enjoyment rights. Then what is the time limitation? Here is the answer. Patents are enjoyable for 20 years if they are granted. Trademarks, designs, and geographical indications initially 10 years, but however, there is a possibility of further renewal for few more years. Copyrights, lifetime of the author plus 60 years. There are also another two types of IPs like plant protection and integrated circuits. Their protection falls from anywhere between 10 to 18 years. Once the given timelines are over, whatever you do, no extension is further possible. So it is time means time. You have to enjoy the rights before these timelines only. After these timelines are over, it becomes a open property. It is no more your property. Rather, it is a open property. Anyone can exploit without your permission. So then I'll show you one more slide on the title IP all-in-one. See this. See the example of Coca-Cola. The bottle, Coca-Cola might come in different bottles. So this bottle shape can be protected as industrial design. The name of this drink, Coca-Cola, or the logo is protected as trademark, which is a brand. And ring pull system, if you take the example of particular bottle, this ring pull system is a technical aspect which is protected by patents. And the creative content on this Coca-Cola bottle is protected as copyright. And the original composition or formulae is a secret. So therefore, a single product or a given article can be associated with more than one type of IP. Here in this example, there are 5 IPs associated with this. So likewise, we all know we are the faculties. We might be finding difficult sometimes to make students understand the concept that we are discussing. These lines by Benjamin Franklin, I really appreciate. Tell me and I forget, teach me and I remember, involve me and I learn. And I generally prefer the third one. So therefore, now time has come for us to make a self-assessment of our learning or understanding on the basic aspect of IPR that just we discussed. So therefore, I have maybe 2 slides, not more than 2, under the title Testing Capsules. It is like self-learning or practice. Okay. So what you all need to do is, I'll be showing an example on the screen. You need to look at that example and try to answer the different types of IPs associated with the given example. So you all need to mention whether the given example is having a patent, a trademark, a copyright, or a geographical indication, or a secret. But it is not just mentioning the names. Trademark for what? Copyright for what? Patent for what? GI for what? Okay, secret for what? Or design for what? So please The time starts now. What are the possible IPRs for this example? You can please put your answers in the chat box. I'll keep this for 30 seconds. Please look into this example, try to correlate with the types of IPs that we just discussed, and also the example on Coca-Cola bottle, or the very first example where I asked you to find out the difference between two paracetamol tablets. Right? This is example number 1. And then comes testing capsule 2. Jendu bomb. We all know that it is generally referred as egg bomb teen calm. It can cure headache, it can cure fever, it can cure pains, right? Or cold. But what are the IPRs associated with this example? So please list out them. And my sincere request is not to just list out the types of IPs, but you should also mention for what purpose the IP is given. If you say trademark, what is the trademark here? If you say copyright, what is the copyright here? If you say patent, for what? Whether you get a patent for composition or a process or a product. So all you need to mention. Fine then. Now, I brought to you the same slide which I had asked you to find the difference. See here, both are paracetamol. The purpose or the applications are one and the same. But however, there are certain differences with respect to IPs. Trademark, if you see the name and logo of the company made, which is making these two products, though product is same but made by two different companies, so their logos and names are different. So trademark, difference in trademark. The creative content present on the box, on these two boxes are different, so there is a difference by copyright. And the tablet shape, see this appears to be rectangular in shape, this appears to be round in shape. So again, as well as the box, so they also differ by industrial design. And then if the products are made by different process, or if the composition is slightly different, then there might be a patent for the process or for the composition. Of course, composition, there may not be any difference in the composition because both are paracetamol. There can be some difference in the process of making. If yes, patent is possible. Otherwise, these three are possible. So therefore, though the tablets are paracetamol, the application is one and the same, but still they differ by the IPs. Now, having this background in our mind, let us try to correlate IP with us who are from academic and research backgrounds. Whatever research work we carry out at our lab or at our institution, we generally refer it as science or technology activity. This research may lead to any of these three outcomes: discovery, invention, or innovation. And here are the definitions for them. Please believe me, creativity is all about the thinking part of activity, whereas doing part is essentially the innovation. If you are efficient in doing, you are working towards innovations. If you are efficient in only giving suggestions or getting thoughts, you are only creative enough. You are a thinker, not a doer. There is ample kind of experience and the number of people available to do this creativity or thinking part. But there is a lack of people who are practicing this, who are practicing either innovation or doing part of the activity. We need more doers than the people who just speak and suggest. And whenever your work is oriented towards discovery, you may majorly end up with publishing them in scientific journals, and which may be protected through copyrights. But for you to get a patent or to get some other kind of innovative protection, either you should work towards inventions or innovations. That means your research need to be oriented towards a innovation or invention or innovation, not just the discovery. And research and entrepreneurship, in my opinion, are almost all one and the same. If you are a researcher, if someone asks you, why are you performing research or why are you carrying out research? We say that my research is targeted towards addressing some issues, solving some problems, right? But what about in entrepreneurship? Essentially, the meaning of entrepreneurship is also the same. If you solve a problem by finding or by suggesting some solution, that is called as research. If that solution reaches to the market and solves the problem in a bigger way, that is called as entrepreneurship. So whether you are an entrepreneur or a researcher, the basic strategy is one and the same. It is all about solving problems. But luckily, humans will always have problems. The problems of 1,000 years back may not be there today. Today's problems may not be there after 100 years, but certainly problems will always be there. So therefore, whenever you have new problems, you can come up with new solutions. Otherwise, always human being will look for newer needs. So they open up new opportunities. If you have one car, after few years, you may plan for adding one more car, two more cars, three more cars. Why? One is sufficient, na? But still, you may find it needful. So therefore, human problems and human needs are like never ending processes. So therefore, always and always, there's a scope for us to add something new. And to cut short this, if your idea solves a problem, that means if your idea is a solution to solve a problem, that is called as invention. So generally, a solution is called as invention, but if your solution reaches to market and brings profit to you, that is called as innovation. So idea resulting into a solution is called as invention. Idea bringing profit is a innovation. All the products, all the brands, all the technologies that we see today in the market or that we enjoy for our livelihood or for our lifestyle, they are an outcome of innovation process. Of course, to get an innovation, there should be some invention. But invention is a small stage activity. Innovation is a higher stage activity. It is through innovation you get the profits. From here, I'll be showing you some examples of innovations associated with IPR, which reflects the impact of this concept and as well as attest to the title research to reality. So research has to reflect in the form of reality. I start with the ring pull system. See this. The inventor of ring pulls can used to obtain 148,000 UK pounds per day on royalties. Just imagine. People like us. The person who invented this is like us only. On one fine day, he got an idea of how come if I invent a ring pull system. Invented, filed a patent, and he was sleeping at home. I don't know whether he was crazy or lazy. Then Coca-Cola, he could license his patent to Coca-Cola. For 20 years, he used to get 148,000 UK pounds per day on royalty. This is the power of IP. See these examples. This boy is Hridayeshwar Singh Bhati, one of the youngest patent holder of our country. At the age of 9, he got a patent for inventing 6-player chess. 6 people can play chess at a time. By 2019, at the age of 12 or 13, he could also invent 60-player chess. 60 people can play chess at a time. We all know Vishwanathan Anand is there, many others are there. And we know that chess is a 2-people game. But believe me, yes, this boy could develop a 6-player to 60-player chess. When a 9-year boy can invent and protect and obtain some benefits, certainly we all can definitely do. The only difference is the commitment. Having commitment, not having commitment. If we are committed, if not immediately, but definitely we can do at one or other day. See this, Michael Jackson. He is so popular, a world craze, right? Even during the days where there was no social media, there was no proper internet, he was so crazed worldwide. Why his dance was so famous? Again, he holds a patent for methods and means for creating anti-gravity illusions. Because he has made this shoe in the manner that he get anti-gravity illusions, only he is permitted to use this. No one else could use similar kind of. Even if they get an idea, even they can make it because he holds a patent on that. When he holds a patent for 20 years, no one can do without his permission. And if someone asks him permission, why he will give at free of cost? They have to pay some monies. Right? Either he may get royalty, or if you use without permission, he will sue you to the court. Through that way, he can earn through penalty. So if you have IP, you can make earnings by royalties as well as by penalties. Both the ways you can do. Now again, cricket fever is already going in our country, and this used to be the case once upon a time, but today is the era of sensor-based terms. And he is the person single-handedly could invent and bring this technology to the market. He holds a patent. Look at the patent title. System for indicating movement of an article from one position or orientation to another position or orientation. When you look into the title, it won't indicate that it is all about the cricket stumps. But if you read the patent document, it is entirely about the cricket stumps only. Here are the diagrams. This is the front page. Single-handedly, single person could invent. And now he controls the entire cricket ecosystem of the world. Few more examples to add to the list. Snuggly Baby Carrier was invented by Annie Moore. She's a staff nurse. She was a staff nurse. She invented. Barbie doll was again a patented invention of 1959. Ramya Jose from Kerala, this girl, she has invented pedal-powered washing machine in 2012. Even this product has been licensed to several agencies. See this. And the ideas behind these products appears to be very, very simple. Even the products also appears to be very simple, but again, they brought huge impact as well as huge benefit to the creators. Especially if you look into Snuggly Baby Carrier, if you try to correlate our historical timelines of 1857, where Jhansi Ki Rani Lakshmi Bai used to be referred as the queen or the fighter who fought Britishers by keeping her baby in her lap. A similar kind of arrangement. Yes or no? This Snuggly Baby Carrier is more scientific, but similar kind of practice was already there into our cultures. But being more scientific, they could file a patent, they could get more advantage. So there are many practices which are already present in our cultures, but somehow we did not give a scientific touch to them. That is where we are seeing a similar kind of products coming from Western countries to India. Few more to add to the list. Modern zipper was a patented invention of 1891, and here is the patent number. Before 1891, there was no zipper at all. But today, our day do not go without a zipper. Our bags have zipper. Our clothes are having zipper. Zipper is one of the very, very essential part of our day-to-day life. In 1949, an antibiotic for typhoid was being granted. Okay, and 1844 was the year a tapeworm trap was granted a patent. 1854, a tapeworm trap which helps in fishing out tapeworms from the human stomach and intestine. 1854. Therapeutic roller or walker was a patented invention of 1986. 1986. Here is the patent number. See this. Electrosurgical device for welding tissues to control bleeding during surgical procedures. Electrosurgical device was a patented invention of 1998, and here is the patent number. Look at this boy. At the beginning of my session, I mentioned to you all that IP is a subject for all. So IP for all. And here is an example of a welder. Saranamuthu from Nagarkoil, a welder by profession, has invented remote control toilet bed system. which is very, very useful for bedridden people. No need of any attendant. If the bedridden people are in minimum consciousness, if they can use their hands lightly to operate with the remote itself, they can easily operate each and everything. That is the kind of creation he did, and he protected it through patents. He has been awarded with National Innovation Prize from President of India, a welder by profession. And look at this women self-help group from one of the Telugu states. They could develop a process of making biochar from human waste, and they filed patents. Now they are marketing this product in several countries. So the process of making biochar from human waste, it is a patented process. And when they made the biochar, they tried to put pack them in this kind of bottles. I don't know whether they have taken the industrial design protection for this bottle or not, but definitely for this name they have taken the trademark. And women self-help group. And we all know that today, in this era of modern, the era which is referred as a modern era, wearing jeans is very, very essential. If you are wearing jeans, you are looked as modern in approach. If you are not wearing jeans, you are very old or very traditional. But believe me, jeans was not for the people like us. It was a solution for mining workers. The problem was working clothes for mining workers do not last longer. That was the problem. Then many research teams started working to solve this problem. Finally, Lewis could come up with the very first and successful solution of the jeans. First jeans was introduced by Lewis. It was a startup during those days. And a solution for the mining workers has become a fashion today. And Lewis is one of the global brands. So this is how a research need to be converted into a reality. This is one of the very famous example to attest to this title. And there's another invention on pat on the back apparatus. See this patented pat on the back apparatus for the lonely ones. Whenever you feel non-appreciated, if you want more appreciations, buy this, put it onto your shoulder, tune it up. Oh, Pawan, great, 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 excellent, excellent, excellent. If you are not clapping me, what I should do? I can buy this. Oh, great, great, excellent. You are very excellent. You are the only excellent. Whatever you wish, you can keep it. See the level or the diversity of the thoughts and the diversity of the efforts which were put into creations. Again, it's a patented invention. Here is the patent number. Sewing machine was a patented invention of 1855. Sewing machine was a patented invention of 1855. Before 1855, there was no proper sewing machine. And few more examples to add to the list. Charles Babbage is the person who invented the computer. Of course, he referred it as analytical engine, but he has not patented. And aspirin, one of the very, very important drug molecule, was a patented invention of 1900. AC was a patented invention of 1906. Before 1900, there was no air conditioner at all. Just imagine how people used to survive during those days. Today, without AC, we cannot survive. Very difficult. And electrophotography was invented in 1942. It's a patented invention of 1942. Mobile phone was invented in 1973 and issued a patent in 1975. And he's the person, Martin Cooper engineer. He's the inventor of mobile phone. And microprocessor was a patented invention of 1974. And here is the patent number. All these examples, you are also finding the patent numbers. If you wish, you can take those numbers and go to Google Patents and search in there in what way they have described their invention. Elevator, the lift we talked today, was a patented invention of 1861. So elevator or the lift that we are using today very frequently is not really a very new invention. It is one of the oldest inventions which was granted a patent in the year 1861 itself. See the level of thought process which has been originated from the people like them. Likewise, there are some lacks of inventions. Yet another example, and very interesting example, fidget spinner. We all know this. Of course, now today it is plentifully available in the market, but she is the inventor of fidget spinner. She's a grandmother. She has invented this to engage her grandchildren. We all know children are very naughty, smart, active, very energetic. So keeping them for 2 minutes or engaging them for 2 minutes itself is very difficult. With that, out of that, she could invent this. But people like us who got some awareness on IPR suggested her to file a patent. She filed it at the European Patent Office and it has been granted. But unfortunately, she was not having Euro 310 to pay towards annual maintenance, because of which patent got abandoned. It came into the open domain, and today this is the worth of spinning toy industry. When I show all these slides, you all may feel that, oh, in what way these are relevant to the researchers like us, in what way these are relevant to the people like us who are from academics. But believe me, creation is something which has no limitation. When people with meager education background could think and create and contribute to something potential with respect to IP, with respect to innovation, certainly we all can do. And in many of the examples that just we discussed, majority of the contributions have come from academic and research communities, because in the Western countries, academic and research is an integrated approach, an integrated practice. Universities will have both research, academics as well as research, but only in India or maybe in few countries we find academics is a different wing, research is a different wing. Of course, there are good number of universities which are doing both, but even then majorly ours is a single window system or single orientation system. If you are in academics, your major part would be teaching. If you are in a research institute like us, major work would be towards research. So that is where we are also finding some difficulty in integrating these two aspects. But nonetheless, please believe me, each one of us, irrespective of our designation, position, education, background, or any other things, each one of us is a born inventor. Every human being is a born inventor. A human mind can generate about 60,000 to 80,000 thoughts per day. Though I am conducting this session here, my mind, some part of my mind is here, some part is also thinking about some other aspects. It is the same for each one of us. Though you are attending this session, maybe as an organizer or as a participant or as a speaker, some part of your mind is here, but some other parts are somewhere else. This happens to each and everyone. Whether you admit or not, that is different, but it happens. Our mind do not keep quiet. It always keeps thinking, generating, looking here and there. So this much potential we do have. But believe me, just ideas do not make any impact. Not all these ideas will be really helpful or really useful. Only few of them will be having some potential. All the intelligence lies in identifying those potential thoughts. Out of 60,000 to 80,000 ideas, more than 95% are repetitive in nature. Very few are having some usefulness. And we need to identify those useful ideas, those potential ideas, and try to work on them. All the inventions, all the creations are an outcome of this approach only. So therefore, whenever you feel that your idea is valuable, your idea is different, your idea is new, it can make something new, it can contribute to something different, certainly you should own it. Otherwise, someone else will do it. Because ideas are no limitation. Today you may get the idea, on the same day I may also get a same idea, right? Like the example of invention of radio. We all know that radio was invented by Marconi, but in reality, radio was invented by our own Indian Professor Jagdish Chandra Bose. He is the person for the first time who contributed to the concepts of radio. In spite of suggestions from his well-wishers to take an IP over that, he denied. After 2 or 3 years, Marconi could file a patent, entire credit has gone to him. It is not that Marconi has copied Jagdish Chandra Bose. No, Marconi was also working in similar lines, because he also got the same thought, same idea. So ideas have no limitation. Anyone can conceive any kind of idea. There can be similar ideas, there can be identical ideas, there can be matching ideas. Anything is possible. So therefore, whenever you get a new idea, if you feel it valuable, you should definitely own it. That is where why IP comes into the discussion. When we say owning of the ideas, it doesn't mean that owning just idea. No, you have to convert your idea into a workable idea. Try to recollect the flowchart that I had shown. If you have an idea, you should work on it and try to convert it into a physical form. Depending on the nature of the physical form, if it is expressive, you may get a copyright. If it is an invention or an innovation, you may get a patent. If it is a name or a logo or an image, you may get a trademark. So likewise, you need to protect. So majorly, when we talk about academics and research, patents are considered to be the most relevant forms of IPR. Trademarks and geographical indications are important for the people who are into business or marketing. And for the academics and research, it is copyrights and patents and industrial designs, or sometimes trade secrets. So therefore, from here, quickly I'll be showing you what are the performances at global and national level with respect to science and technology and its conversion into inventions. These are the countries which are performing very well at the global level with respect to scientific publications. India stands number 3. Very good. We need to appreciate. We need to feel. We need to feel proud and take pride in this. But look at the percentage share. Ours is only 5.3. But who are at number 1 and 2? What is their share and what is our share? And who are there at number 4, 5, 6 and what is their percentage share? If you look into these things, we are not in really a very healthy position. Countries at 4, 5, 6 can surpass us at any time, but we can hardly reach to any of these two. So that means we are still lagging the race. And with respect to patent filings, these are the top 5 countries in the world: China, US, Japan, Korea, and Europe. These 5 countries contribute to more than 85% of the patents. And if you want to know the numbers, Chinese patent office receives more than 16 lakhs patents in a year. American office receives more than 5 lakhs, or almost 6 lakhs. But Indian patent office hardly receives about 77,000. Okay. Where is China with 16 lakhs, US with 6 lakhs, but India hardly about 75, 80,000. And with respect to trademarks, again, China contributes to more than 40. China alone contributes to 48%. But of course, India also finds a decent numbers here with 3.2%, because India, with a population of 140 crores, is a very, very attractive market for any kind of products and any kind of services, not only by Indian companies, but also by foreign agencies. And here are the numbers. China files about more than 75 lakhs of trademarks. America IP office receives more than 7 lakhs. And of course, Indian IP office also, trademark office also receives about 5 lakhs trademark applications every year. A good sign, good numbers. May not be equivalent to China, but yes, comparatively very good. Industrial designs, again, China takes the lead with more than 53%, but India do not find any role here in top few contributions. See here, if you see the numbers, Chinese designs office receives more than 7 lakhs industrial designs annually. European receives 1 lakh, likewise. But where is India? Our Indian design office hardly receives about 15,000 applications in a year. So therefore, there's a big question mark. Though lot of academic and research activities are going on with respect to engineering sciences, with respect to devices, with respect to others, but those efforts are not really reflecting in terms of industrial design filings. We need to seriously look into this. And then coming to the geographical indications, China has got more than 9,500 geographical indications. And India, we have only 429 geographical indications. These are registered GIs in India. Of course, you all should be happy. You all, in the sense, maybe not all the participants, but as organizers, definitely, or the people who are from Tamil Nadu, in particular, should feel more happy that it is the Tamil Nadu as a state which has got highest number of registered GIs from India. It has got more than 55 GIs, starting from Tirunelveli Halwa to Madurai Malligi to Madurai Saugandi to many others. There are more than 55 registered GIs. Then Kerala, Karnataka, likewise, every state has got good number of GIs. And here is the trend. See this trend. For 5 major IP offices of the world, mainly the patents, China, US, Japan, Korea, and Europe. So it is the US which started a very, very systematic of patent practice from 1790 onwards. Then comes the Japan. Japan started a systematic practice of patents by looking at the US. Then the Korea, and then the Europe, and finally the China. China has started its very systematic practice of patents only from the year 1985 onwards. But within soon, China could become number one in the world. US is strategically doing good. Others are also doing good, but China, there's a huge progress. It started very late in 1985, but within soon it could emerge as the number one country with respect to patent filings. And if you want to know about Indian practices in last 5 years, here is the trend with respect to different types of IPs in India, starting from 2018 to 2023. Patents 50,000, 56,000, 58,000, 66,000, 82,000. Even designs, trademarks also, there's a good increase. Of course, as a country, the numbers of IPs filed year after year is quite good. They are increasing. But however, this increase or this progress is not really sufficient enough for us to be in a global competition. On one side, China, US, and others are filing patents in some lakhs, but our numbers are hardly in some thousands. Of course, we are making some improvement year after year. As I mentioned, again, I am repeating, though we are improving, this improvement is not really sufficient enough for us to be in the global competition. So therefore, we need to file more. We are doing, but we need to realize the value of converting our research into patent applications, research into industrial design applications, research into IP as a whole. Here is a chart which gives the state-wise number of patent applications filed. Again, people from Tamil Nadu should feel happy. It is the Tamil Nadu which stands number one in the number of patent filings annually. Tamil Nadu as a state files about more than 7,600 applications, followed by Maharashtra, Uttar Pradesh likewise. But whether it is Tamil Nadu with 7,600 or Himachal Pradesh with 279 or Odisha with 500 or Rajasthan with 1,200 or Telangana with 2,400, in my opinion, all these are poor. All these are poor. 200 is poor, 7,000 is also poor. Maybe when you look into these numbers very specifically, 7,200, yes, there's a big difference. But as a whole, this is not good at all, because many of the states listed here are having a population of at least 3 or more than 3 crores. Population is running in crores. Contributions are running in some lakhs to crores, but hardly they are reflected into IPs. And these are the top 10 academic institutions which filed most number of patents in last year. Lovely Professional University, Jain University, Galgodias University, likewise. Even all IITs collectively, they could file more than 800 patents. So irrespective of a engineering institute or a technical institute or a medical institute or a science institute or other institute, every academic institution has got a privilege of filing good number of patents. One great advantage for academic institutions is from 2021 onwards, Government of India has given an 80% reduction, in all kinds of fees associated with patents. Patent filing, patent examination, patent processing, patent annual maintenance. In every fees, there's an 80% reduction for the academic institutions. You are a college or a university or an institute, whatever it may be. Yes, if you are academic institute recognized by UGC or AICTE, yes, you get 80% reduction. There is a big advantage. And here is the list of designs filed by different states. Maharashtra, Gujarat, Tamil Nadu likewise. Of course, every state contributes, but again, these numbers are not really encouraging. These numbers need to be multiplied with great factors. And here is the list of number of trademark applications filed by different states. Maharashtra with more than 85,000, then Tamil Nadu 26,000, Delhi 64,000, Gujarat 47,000. Likewise, every state has got good number of trademark applications, because we know that in India the culture of startup entrepreneurship is growing like anything from last few years at least. And India is a very big market for local as well as the other goods. So therefore, always there's an encouraging contribution with respect to trademarks. Of course, these numbers are not really equivalent to that of China, but definitely they are good. And here is the list of GIs from different states. As I mentioned, Tamil Nadu stands first with 55, then Uttar Pradesh, Karnataka, Kerala, likewise. Every state has got some good number of GIs. And quickly I'll show you the comparison of performances between the countries like US, Japan, China, and India. Look at the slides very carefully. First US patent was issued in the year 1790. Before that, there was no patent in US. This was given for a chemical process of making potash. And this is how American patent system has practiced and improved to a greater extent. By 2021, American Patent Office could receive more than 11 million applications. So this is how they were practicing it in a very, very systematic manner. And if you happen to visit American Patent Office, this is what is written there. The patent system added the fuel of interest to the fire of genius by Abraham Lincoln. Even he himself has got a patent, manner of bowing vessels. And this is the patent number in the year 1849. Japan, as I mentioned, the very first patent in Japan has come somewhere in 1880s or 1890s. But then the major reason was this. Please read this statement very carefully. This is very, very important, because we always look for someone with whom we can inspire and whom we can admire the most and whom we try to follow. That is what is done by Japan. We have looked about us to see what nations are the greatest so that we can be like them. We say, what is it that makes the United States such a great nation? And found that it was patents. And so we will have patents. You see Japanese progress. Until early 1900s, though Japan was filing patents, but their numbers are not really good. But after 1900 onwards, within soon, they could contribute more, and within soon, they could emerge as one of the superpower. That is the kind of inspiration one need to take. And here is about the China. First patent of China has come only in the year 1985. Before 1985, China was not having a proper patent system, patent law. 1985 is hardly few years back, maybe 30-40 years back. But within about 35 to 40 years, they could emerge as most patent filers of the world. And what about India? The first patent in India has come in the year 1856. Okay, China is 1985. Ours has come at least 150 years, 130 to 140 years before China has got the patent. And he is the person who got the first patent in India. And this is the entire patent document, scan copy. And this is the first page of the copy. Facsimile of the first specification and drawing for grant of exclusive privilege in India. At that time, the terms like patents, trademarks, intellectual property were not into use. But of course, practices are there. IP is one of the old practice. Taking protection, giving privileges are one of the oldest practices. But the terms that we are using today might be new, but not the practices. We need to realize this. Again, I brought you the same slide. America started in 1790. Japan started in 1885 or 1900. And Korea somewhere in 1960s. And Europe, again, a similar line in 1970s. But China in 1985, within soon emerged. But India, which started in somewhere in 1856, between these two, 1856, but hardly we find anything here. So we have neglected this. or we have ignored this, or we did not realize this activity to the extent that which was supposed to be realized, because of which we are suffering a lot. But however, India is very well recognized, is identified as the land of many first. It is because of this reason India has witnessed many foreign invasions, right or not? Many people came to India, tried to capture India, tried to rule India. Of course, there are huge number of contributions from Indian side to the world. These are some of the examples of innovations during 320 to 520 AD, and it is a carving taken from one of the temple of Tamil Nadu, Aridurai. See this. This temple may be 1,000 or more than 1,000 years old temple. Before the invention of microscope itself, our people could able to carve the process of embryo formation on the hardest stones. How nicely they carved it. See, very, very, very properly they carved. Even today, even after looking into the microscope, picturizing the process of embryo formation is not this fine. That means the science and technology was already there into practice. Not only this example, go to any temples or any heritage sites, lot of carvings are already present there. And look into this hair accessories, all these things, even 3D structures on the hardest stones were into practice. But what happened to us today is we are still suffering, struggling to survive and to showcase that yes, we are also in the global competition. Somehow we are facing this difficulty. The reason being, maybe our approach was not scientific in nature from the beginning, or maybe we got some disconnectivity. And I brought some very interesting literature to add to this concept. In India, the concept that one could have property rights over the products of one's intellectual labor is yet to gain a firm footing because of the fact that traditionally India is a country where people never believed in asserting rights over intellectual properties. Yes or no? This is true. We have seen all the saints, rishis, munis, whomever we refer in our culture, they were the scientists, but hardly they were rich. Factually, intellectuals were identified more with poverty than with property or prosperity. People took pride in proclaiming that the goddess of wealth and goddess of learning never coexisted. This was into our culture or into our practice. But there is a famous saying by none other than Tiruvalluvar. We all know how great Tiruvalluvar is. I need not mention to anyone in the country. According to Tiruvalluvar, the greatest incentive for a learned person is to know that his learning contributes to make the world happy. If you create something new, if you develop something new, if it is making world happy, you are so happy. You take pride in that. You feel proud for that. But today's scenario is not like that. Today's world is not like that. Today, if you do something, if you create something, you should also get benefit out of that in a monetary manner, in a financial manner. So this is why most of the proud products of our culture and contribution of our ancestors to arts, literature, social, natural sciences, technology, etc., remained in anonymity and remains the reason for loss of recognition and contribution of our ancestors towards intellectual labor and culture. And also, we did not have a systematic practice of record keeping. Even today, majority of our research work, we do not keep proper records. Whenever it is very much required, whenever it is made mandatory, then we try to make up the records. But otherwise, we do not have the practice of maintaining a proper recorder. This is also one of the greatest drawback in our practices. So there are many things which were contributed. So therefore, with this background, we all should realize that we are in the age of innovations. And in this era, we need to be attentive. And please see these lines by Jagdish Chandra Bose. They appear to be very much relevant for all of us. India is drawn into the vortex of international competition. She has to become efficient in every way. through spread of education, through performance of civic duties and responsibilities, through activities both industrial and commercial. Neglect of these essentials of national duty will imperil our very existence. Yes or no? This is 100% correct. Whether you are a faculty, you are a student, you are an entrepreneur, you are a startup, or you are a businessman, or you are a less educated, more educated, half educated, or over educated, whoever it may be, for everyone it is relevant. So therefore, in this era, these are the three major activities which are to be implemented and practiced: creation, protection, and exploitation. But when it comes to creation part, we are very efficient. We have great minds, we have great ideas, we do great research. We are creating, we are doing. But unfortunately, when it comes to protection part, hardly we have any education, hardly we have any awareness on this. Neither we were taught nor we were nurtured. That is where we are lagging. Because we do not protect, certainly we cannot think for exploitation. So therefore, the time has come. We need to realize the value of protecting our creations. Once we protect, we get the rights in the form of IP rights. Once we have these rights in our hands, we can exploit them for making profits. Once we make profits, we can put them for further more creations. So this cycle will keep going on. This has been realized, adopted, and practiced very, very systematically by the individuals, by the organizations, and by the nations at large, whom we refer as advanced or developed. Look at any organization, look at any individual, look at any nation. If they are developed, if they are advanced, they are doing these three in a very, very perfect manner. So then what comes as a major difference in the practices with respect to academic versus industry? Academic or research institutions, their focus is for knowledge sake. They generate knowledge, they keep generating knowledge, more and more knowledge. But industry work on management of knowledge for profit sake. Believe me, any kind of advancement or the progress of an organization, of a nation, happens majorly because of the industrial outcome of your thoughts. It is not just the knowledge that is being created. How you utilize this knowledge and how do you manage this knowledge to advance your societies? Again, it needs to be managed and there should be some profit making aspect. That is where in today's scenario, the research work is referred in terms of TRL. If your research is oriented towards TRL, then you are on the right track. If your research is not oriented towards TRL, better don't do any research, not required at all. In this scenario, most of the academics and institutes, their research work it comes under TRL 1 to 4. It is mostly basic in nature and discovery oriented. But industry or the products or the brands or the technologies that we are seeing today in the market are an outcome of research of TRL level more than 8, 9 or 10. If your research is on a scale of TRL 7, 8 or 9, then there is some scope for industrial application. And all the development, all the advancement is majorly because of the research happening at this stage or the research which has gone to this stage. And there exists a gap. And this gap is between the academia and industry. Industry needs this side, but academia hardly works on this side. So this valley is referred as death valley or valley of death. And unfortunately, in our practices, in Indian practices, this valley is so deeper that it is becoming very, very difficult for us to minimize or nullify. Forget about the nullification, but minimizing this gap is also becoming difficult because it is so deeper. We need to come out of this. And certainly, this minimization can be achieved with the help of IPR, because IPR, intellectual property rights, acts as catalyst to minimize the gap between academia and research, academia research versus industry. So IP is the measure of innovation or technology and economic progress of a nation or of an organization. See the difference here. There are only few countries which are referred as advanced economies, right? Maybe about 10, 15 countries, but all are rest of the world. By population, advanced economies are very small in number. GDP wise, they are very huge, very high. Publications wise, they are huge. Small countries, huge publications. But when it comes to patents, they are the only countries in the world. Rest of the world is having more than 190 countries, but hardly their numbers appear anywhere. So this itself is a direct indication that very few countries, maybe 5 to 10 countries, are dominating the entire world by way of intellectual property, by way of innovation, by way of inventions. And by now, you all must have realized that technology growth or technology creation or technology contribution or technology development is a direct indication of intellectual property contribution. If you have more patents, it relates that yes, you have contributed to good number of technologies. So whenever you try to look at a technology, most of the available technologies are coming from any of these 5 or 6 countries: US, China, Japan, Korea, Europe, some other countries. That means technology is directly related to IP, or IP is directly related to technology development. So therefore, if we ignore the practices of IP, we can never become a technology oriented culture. So therefore, always remember, inventions are incomplete without a patent grant. An invention without a patent is same as treasure without security. Anyone can steal it, anyone can claim it. Today, we all are participating in this program, or we all are at our offices, at our organizations. Did we lock our home or not? Why did we lock our home? Because we have a lot of belongingness. We want our home to be safe. We logged it and came to the office. But when it comes to research, we say we are just happy with the traditional practices. We don't want to do new. Even if we do new, let it be open. So therefore, we need to adopt a similar kind of safeguarding approach for our research, and we need to definitely protect our creations. That is where now we have come to. So, knowingly or unknowingly, or whether we agree or not, each one of us, whether you are from academics, or research, purely research, or academic research, whatever it may be, we are in this phase, a phase which is referred as transition phase. What is the reason? We are doing research, great research, but we have the habit or practice of converting our research into scientific publications or keeping them as know-hows. But now everyone is talking about IP. Even organizations, authorities, even the government is also asking us IP. So that is where the difficulty comes. So then how to tackle with this? Believe me, whenever you are in such a state of transition, always try to take a patent first or IP first. If you take patent first, you will also get a publication for the same work. It is like 1+1 offer, provided if you take patent first. But reverse is not possible. So therefore, there are more benefits by obtaining patents. Whatever benefits you used to get from publications or your research by way of visibility, credibility, publicity, all these will be multiplied. And also additionally, you will be getting a industrial viability, industrial connectivity if you take patents. So patents will always add value, more and more value to your works. Then how to tackle with this situation, or how to how to how to take this patenting activity forward? So all you need to do is, please look into these few slides very carefully, because they have a decent connectivity which will help you in analyzing your research works, whether they are really to the extent of taking patents or not. The very first thing is, while you plan a new research work, you should be in a position to identify whether you have a patentable space or not. You have to locate the patentable space for your work which you are going to start. That is the first step. And while you start working, or while you begin your new research, you should remember that all work, whatever work you do, it may not get you IP. There are certain criterias which need to be satisfied for a research work or for an invention to be patentable. It can be referred as NUNS test, NUNS test: novelty, utility, non-obviousness, and statutes of the nation. So if your research work or if your invention, if it satisfies these 4 criteria, yes, it is patentable. Otherwise, no. This Of course, after submitting your application to the patent office, during examination, they will assess whether your application, whether your work is satisfied with these 4 criteria or not. But why do you wait till then? If your work is not falling into these 4 categories, or if your work is not satisfying these 4 categories, better don't waste time in filing patents, because anyway it is not patentable. So therefore, as a researcher or an inventor, it is your duty to assess your work whether it is eligible for filing patent or not. And the very first test here is, whenever you are planning to file a patent, please don't disclose in any of these manners, neither by written form, nor by oral, nor by demonstration, nor by use, nor by in any other manner before filing the application. If you do so, it is called as prior art. It is known, then it will not be applicable for considering the patent. And please also don't publish in any of these things, any of these non-patent literature before filing your patent application. No, you should not publish. No publication, no poster presentation, no abstract submission. Nothing should happen as before filing the patent application. Once you file your application, you can do any of these things. But before filing application for the patent, you should not do. And there are some inventions which are listed in the Section 3 and Section 4 of Indian Patent Act 1970. In spite of satisfying the criteria of patentability, even then they are not patentable, because as a country, Indian Patent Act do not allow these kind of inventions for the patents. That also we need to remember. If your work is falling in any of these categories, please, it will not get patents. It will not fetch patents for you. Better don't make an attempt. So therefore, you need to be in a position to assess your work. Any invention which is frivolous, against to the nature, or if it is a discovery of living or non-living things, or it is against the public moral or animal or environment, or it's just finding a new form or a property of the known substance, mathematical or business method of agriculture or horticulture, or a invention which is all about a mental activity, or a composition or a compound which is made by known components with known properties, presentation of information, literary, dramatic or musical or artistic works, or any, if something is already known traditionally, arrangement or rearrangement or duplication of the known devices, or method of diagnosis, method of treatment, method of operations, computer programs as such, any inventions related to atomic energy. If your work is falling in any of these categories, better don't think of filing a patent, because even if you file, it will not be granted. During the examination, it will be rejected. The reason is, according to the statutes of the nation, the inventions listed in Section 3 and Section 4 of Indian Patent Act 1970, they are not allowed for patents. Of course, my friend Dr. Yogesh Dhoble would be talking to you in detail about all these aspects, like criteria of patentability, non-patentable inventions, all these things in detail. Again, I brought to you the same slide. Tell me and I forget, teach me and I remember, involve me and I learn. Now quickly I'll show you few examples here. What all you need to do is look at the examples. We just discussed about the non-patentable inventions and try to assess whether the given example is patentable in India or not. Example 1, see this. You should assess whether, see the example as such given on the screen. Try to assess whether this is patentable in India or not. If yes, why? If no, why? We also should give the reason. This is one. You can put your answers in the chat box, or maybe I'll also tell here. See this. This is a method of taking body scan. This is a method of diagnosis. And according to Indian Patent Act 1970, method of diagnosis, method of operation, method of surgery are not patentable in India. So therefore, it is not patentable. Look into this. Butter stick. We know today world is very busy world. We don't have time for anything. I thought of making this because we can avoid going to canteen, standing in line, eating for longer time. Maybe even if you bring a tiffin box also, you have to open it, eat it, clean it, wash it, keep it. Why? A lot of time is going there. So better butter stick. But is it really patentable in India? Maybe it is new, you have not seen in the market. But Is it really patentable? Answer is yes or no. If yes, what is the reason? If no, what is the reason? Here the answer is no. The reason is we already have Fevistick and lipstick in the market. It is a similar kind of product. So therefore, there is no newness in this invention. There is new, it might be new, but there is no innovativeness. There is no innovativeness. It appears to be quite obvious when you look into Fevistick or lipstick. So therefore, it is not patentable. See this. Umbrella fitted with a fan. I just told you, if you bring 2 or 3 devices together where they have their own work, there is no new work being generated. In this case, fan is doing fan's work, umbrella is doing umbrella's work. By bringing them together, there is no additional work, or there is no new work, or there is no new advantage. So therefore, it is only duplication or arrangement or rearrangement of the things. Again, not patentable. And so now quickly in about another 5-6 minutes, we try to conclude. I'll show you some important slides very quickly. See, to now to face the situation and to come into the practice of making more patents, apart from searching for literature, we should also start for searching in patents. See, whenever you do research background or literature survey, we hardly look for scientific publications, but more than 80% of information is available in the patents. And why patent search is important? Just to make sure that you are not repeating the same thing. And believe me or not, 80% of the technical inventions will appear only in the form of patents. There are more than 150 million patent documents worldwide. And patent search is not that simple. It needs efforts, it needs time, it needs some kind of intelligence. But of course, at the same time, it is not difficult also. So therefore, we need to be very, very careful in designing, planning, designing, and executing your research. Wherever there is a scope, you should go for filing patents. Then how do you do that? By using the patent search or by conducting the patent search. And people will ask me, we are ready to do the patent search, but how to do, where to do? Answer is here. There are good number of freely available databases from where you can search for patents. Google Patents is there, Lens.org is there, WIPO Patent Scope is there, eSpaceNet is there. These databases are free. They also give global coverage. Apart from this, all country-specific patent offices will also provide the databases. And there are some paid databases like Questel, Patser, STN, LexisNexis, and Derwent. They're paid, they're costly, but they give very exhaustive information. They give very organized information. Paid database, in simple terms, paid databases are like supermarkets. Free databases are like local markets. Material available is same. The way it is made available is different. So it all depends on you. If you can afford for paid database, you can go for that. Otherwise, you can very well do it from free databases. And these are the different kinds of patent searches one can really perform: novelty and patentability search, or freedom to operate search, infringement search, invalidity, competitor assignment search, Burr sequence. If you're a chemistry person, structure or marker structure, or if you want to know each and everything, then you can go for a landscape or technology search. Of course, I'm not going into the details of any of these things because each of the search type itself is a big subject again. I'm just quickly introducing you the various possibilities. Why IP search or technology analysis is required? To know R&D developments, to draw the state of art, to identify geographical trends, to find who is making what. All these things you can find out by IP analysis. Quickly, I'll show you one example. What you all need to do is, whenever you find a topic, go to Google Patents, type in there your keywords, get some relevant patents. From there, you can identify more and more scientific terms, more and more terminologies, whatever is possible. Again, by using them, you can make a proper search. And once you perform the search, whatever results you get, you try to screen them, relevant or not relevant. Whatever is not relevant, you just forget. Whatever is relevant, from there you can make a systematic analysis. You can map who is what, whether the patent is from academics or from industry, or whether a patent is talking about the product or a process or a composition, whether the material used is same. If not, what kind of differences are there, in what are the characterization methods they have used. All these kind of analysis one can do. quickly I'm showing you one example of nanotechnology patent analysis. We took we restricted from 2001 to 2012 for nano additive cement. Okay, and see, whenever we searched, we got more than 3,000 patents, and when we have screened them for relevant and non-relevant, finally we could end up with more than 368. So from these, we could make this year-wise trends. Out of this 368 on yearly basis from 2001 to 2012, what are the year-wise number of patents? And in 2011, we could file more than 100 patents. These are the geographical trends. Out of these 368 patents, which country holds the most? China holds more than 154, followed by Korea likewise. India also has got 5 patents. And which are the top 10 companies filed most number of patents? These are the top 10 companies. What are the fields? Distribution of patents by the type of nanomaterial used, nano zirconium oxide, carbon black. So there could be different nanomaterials. So those fields we can find out. And nanomaterials and their characterization, even materials versus property. And what are the top 10 technologies against the year? Each year, which technology got most number of patents? And which are the types of assignees? How many patents are from government agencies, from universities, from the individuals, or from commercial organizations? And who is collaborating with whom? Sometimes people may not be really interested in giving you correct answers for the collaborations, but by conducting IP analysis, you can find out who is collaborating with whom and which company in each year-wise filing of patents by different companies or assignees. Suppose if I say that I am from my lab, we are filing every year 10-15 patents, whether that is true or not. If that is true, what are the exact numbers? How many number of patents we filed in 2020, 2021? All those information you can get by IP analysis. So therefore, here to summarize this IP strategy or IP analysis part, I have one quick slide to show you. What are all you need to do is, whenever you complete the work, you try to screen the work for its patentability. Before publishing papers, you try to screen them. If there is some scope, try to take a patent first. Then you can also publish the same work. It is like 1+1 offer. So therefore, screening of research works for patentability before publication in scientific journals has to be made as a very, very regular practice. Any publication, any application, or any research work comes for publication, you have to screen that whether it attracts some patents or not, some IP or not. If so, take IP first, then go for publication. By doing this, we can improve the numbers, we can improve the productivity, we can improve the both quantity and quality. But as a culture, we also have some limitations. These are 3 major limitations that I feel when we are physically present but mentally absent. When I was a student, I was doing this, but now I'm a faculty, I'm experiencing this. As a team, we are not that successful as in a team. So we are not so successful by working as teams. We need to overcome this. And the third one is the risk. It is the risk which drives the innovation. But we are not a risk-taking culture. But we need to realize that this era is a competitive era. And it is the innovation which distinguishes between a leader and the follower. Luckily, everything starts with an idea. It is the idea which can make us a leader or which will keep us as a follower. So we need to come out of the ideas, not just the ideas, but the smart ideas, specific, measurable, achievable, realistic, and timely. If you have this idea, certainly we should work on that idea. And here, this would be the impact of a leader versus follower. So always try to be a leader. Then how to become a leader? They're very simple. 3 questions are there. If your answer is yes for all these 3, you will never become a leader. Poor risk taker, credit seekers, and safekeepers. If your answer is yes for all these 3 queries, this. If your answer is yes, don't worry. You will never become a leader. So you will always remain as a follower. Whether you do, don't do, whatever you are there, you will still be a follower. But then, if you really wish to become a leader, even if your answer is yes now, but still there is a chance for us to make our answers no for all these 3. Are you a poor risk taker? Your answer should be no. Are you a credit seeker? Your answer should be no. Are you a safekeeper? No. If your answer is no for all these 3, certainly you have, or you can develop a great potential to become leader. So that is what is required. And this would be the scenario if we do not have IP assets. Big will eat small, small will eat further small. So being small without IP is so dangerous. And whatever small you may be, if you have IP, you can be a hero. You can stop anyone. You can fight anyone. So you'll be so dangerous, provided if you have IP. And with this cartoon, we can narrate, or we can explain the complete essence of IPR. IP, if you recollect, IP is creations of the mind. And once you protect them, you get the rights. That is nothing but intellectual property rights. Why do you need those rights? If someone tries to exploit, you can stop them. This is all about intellectual property. And top 500 companies of the world, their asset value is changing from being traditional to intellectual. Now, more than 90% of assets of top 500 companies in the world are intellectual property assets. You don't find building, you don't find make big equipments, but yes, they are largely in the form of IP. That is the power of IP. So therefore, it's a very high time, like the times of 1942, where the slogan was "Do or Die." Our ancestors did it so that we are living in a free country. Now it is all about innovate or die. Innovation keeps us recognized. Otherwise, we will be ignored. Ignorance is equivalent to that. So therefore, we should not give any chance for the ignorance. We should definitely innovate. And he is a great inspiration. Professor Robert Langer, he is an engineer by training, but more than 200 papers, more than 1,000 patents. His patents were licensed to more than 250 companies. He got more than 200 awards, and he is only one of the 5 living individuals who secured Medal of Science, Medal of Technology, and Innovation. So we need to be an integration of like this. A research need to be integrated for these kind of activities. And quickly, I'll show you some of my research works which have been converted into patents. Otherwise, you all feel that I am only theoretically talking about IP. But these are some of the works. I'm an organic chemist by training. We always try to design and develop new molecules for various applications. There are some examples. And these are the front pages of the PCT applications from some of our works. And there are a few more examples. We develop new processor for the existing molecules. We develop new molecules. We develop hybrid molecules. So we also develop molecules based on the natural products. So several kinds of research we are doing. And this work more specifically I want to mention about. This is the work for the first time where we thought of filing patents in 2015. As I told, before 2015, we were not having any patent. Only in 2015, for this work, for the first time, we thought of filing patents. We filed 4 patents, one in India, 2 in US, 1 in UK. At that time, our intention was to file some patents so that we can get some numbers. Those numbers we can reflect in our profiles. That was the only intention, to be frank. But luckily, our efforts were really good or really fruitful. Within 5 years, by 2019, those 4 patents were licensed to Sun Pharma, and our institute received 5 crores royalty. That itself is a greatest attestation to the work we have carried out in 2015. So because it is a patent, we could license. Because we license, we could earn money. Otherwise, we could have, of course, after filing patent, we have also published this work. Suppose if we have not filed any patent for this, even if we have published this work in Nature, there would not have been any future. The reason is, even if you publish in Nature, people can go through your publication, they can still practice without your permission. So therefore, having patents for the works where you feel it is important is very much required. So these are the 2 American granted patents front pages from the works, and this one is for the work which we licensed. This one is the work on process for nicotine. And these differences always one need to remember while practicing publications versus patents. Whenever you are practicing publications, author, manuscript writing, and affiliation goes, but while making patents, you should use the terms like inventor, specification, drafting, and assignee. So these are very, very important. If you come to me and say that, sir, I am the author of 5 patents, there itself I will catch you. That means you do not have proper understanding on patents. So instead, you should say, I am the inventor of 5 patents. I am drafting a specification for the patent. But when you say publication, I am writing a manuscript. I am the author of paper. Yes, that is with respect to publication. But when patents, inventor, specification, drafting, assignee has to come into practice, because patent is a techno-legal document. So therefore, knowingly or unknowingly, our research orientation has been mainly, sometimes I refer it as only also, towards making impact factor publication first. Of course, This is very much required. We are doing this very efficiently. We need to do this. There is no doubt. But unfortunately, we are just happy by doing this. Each coin has two sides. If you are happy with only one side of the coin and keeping other side blank, that will not be valued in the market. Similar is the case of our research practice today. So therefore, in addition to this existing practice, now the time has come for us to be reoriented towards India first, innovation first, and IP first. Whatever activity you take up, it should add value to the nation. Whatever works you carry out, there should be some or other innovativeness. And wherever there is a possibility, you should take an IP first. By doing these three practices, along with the existing practice of making publications, certainly we can do wonders. And this is how CSR is now reflected as the innovation engine of India. Of course, we are doing innovation since long, but then we realize this, and now it has been directly reflected through our logo also. And these are few programs which we conduct to nurture people around us on the aspects of IPR from our institution. New IPR, NEET IPR, IPRAT, IP Maxima likewise. And every year we keep sensitizing more than 50,000 to 1 lakh people. And very recently we have initiated another program called CSR IPRAT. This is a very unique and new and very first of its kind of program in the entire country. Odisha is a land of Lord Jagannath, where Puri Rath Yatra is very famous. In similar lines, we thought of bringing up CSR IP Rath. Through this program, in about 20 days, this is a mobile IP campaign. In about 20 days last year, July, we could sensitize more than 1 lakh people. This has been highly appreciated in all levels, including the Ministry of Science and Technology. And even the national portal on Azadi Ka Amrit Mahotsav has also cited this. So with this, before I show the thank you slide, we all must remember that Vigyan Sarvatra Pujyate. It is a well-known saying, right? Vigyan Sarvatra Pujyate. If you are educated, if you are knowledgeable, you will be respected and you will be valued wherever you go. It is true. And similarly, what I feel is, it is the Anusandhan Sarvatra Vijayate. If you have innovation, wherever you go, you can see success. If you have innovation, wherever you go, you can see success. Now, we all need to orient towards making some new innovations. It is the innovation which keeps us valued. So with this, these are some pillars on which I made this presentation. Being the very first session, I thought it should be more and more depictive, and it should be impressive, it should be effective. We should also have some kind of interaction. And finally, all the information need to be given in a very, very proper manner by the concept of seeing is believing. For that reason, I use several examples with proper citations. It is not that we need to have any sessions with a very serious mode. Always there should be a balance of everything. So these are some interactions which are memorable in nature with the people, eminent people in science and technology from India. I could interact with them very closely. It is not just because of chemistry, but it is majorly because of intellectual property. With this, I thank you all once again. Thank you. I just stop here. Thank you all. And if there are any queries, we can take them. I am done from my side. Hello. Yes.
Thank you, sir. Thank you, Dr. G. Pawan Kumar, for your enlightening and inspiring speech on innovation and intellectual property rights. Your profound insights have provided us with a deeper understanding of the importance of these concepts in academia and research. Your speech in differences in copyright and patents, importance of patents and inventions and power of innovations like small stage activity, higher stage activity, and examples of biochair from human and explaining the waste, human waste, toilet chair, and working clothes, and explaining details about three major activities like creation, protection, and exploitation. This session went very informative and useful, sir. Your expertise and wisdom have undoubtedly left a lasting impression on all of us present here today. We are truly grateful for your valuable contribution to our faculty development program. Now it's time for question and answers. Participants, if you have any questions, kindly post it in the comment box. All are commenting like informative session.
And I hope I have done a reasonable justification for the cause of inviting me to this program.
Yes, sir. Okay, let's at the end of the session. Now as we draw towards the conclusion of this inclining session, it is my pleasure to invite Mr. A. Kameshwaran, Assistant Professor, Department of IT, to deliver the vote of thanks.
Thank you, ma'am. Myself, Kameshwaran, Assistant Professor, Information Technology, Dr.M.G.R. My great honor and privilege to propose vote of thanks on this occasion. Let me first thank Almighty for making this event a resounding success. And then I thank our speaker, Dr. T. Pawan Kumar, Senior Scientist, CSIR, IMT Bhubaneswar, Innovation and IPR for Academic and Research. Thank you, sir, for such a knowledgeable and enlightening session on intellectual property rights and patent innovation. It's my pleasure to thank our Honorable and Dynamic President, Engineer ACS Arun Kumar, sir, who has been a great continuous support system and always encouraged us to take a step forward and stay ahead. I also thank our Vice Chancellor, Dr. S. Geeta Lakshmi ma'am, our Registrar, Dr. C.B. Palanivelu, sir, Additional Registrar, Dr. V. Cyril Raj, sir, and our Advisor, Dr. Mehta, sir, and Dean ENT, Dr. Etraj, sir, for their guidance and encouragement in all our efforts. My heartfelt thanks to my head, Dr. N. Kanya, and my dear colleagues who have worked hard and ensured that this event becomes a milestone. And my special thanks to our participants who actively participated. Once again, I thank you one and all for your attention. Thank you.
I extend our sincere thanks to you, Mr. A. Kameshwaran. Your contribution has added immense value to this gathering, and your words have left a lasting impact of all users. Thank you once again for your expensive vote of thanks, and thank you to all the participants for your valuable contributions and unwavering support. Attendance and feedback link will be posted in the comment box, and attendance and feedback link. This link will be available only for the next 20 minutes. Participants who have attended the session, kindly post your attendance and kind information for the participants. Certificate will be given only for the participants who have posted attendance for all 5 days.
Dr.M.G.R. Educational and Research Institute University welcomes you. Our motto is to be a center of excellence for quality education research in the fields of engineering technology, dentistry, science, and humanities. Now, we are taking a look at the various departmental buildings of our campus. Faculty of Engineering and Technology. We have separate buildings of all engineering branches. Mechanical Engineering, Electronic and Communication Engineering, Electrical and Electronic Engineering, Computer Science and Engineering, Electronic and Communication Engineering, Biotechnology, ACS Medical College and Hospital, Chennai, Anatomy, Biochemistry, Physiology, Biochemistry, Forensic Medicine, Pharmacology, Micropathology, Faculty of Dental Surgery, Thai Mogambigai Dental College and Hospital, Oral Medicine and Radiology, Department of Oral and Maxillofacial Surgery. Department of Prosthodontics and Crowns and Bridge. Department of Conservatory Dentistry and Endodontics. Department of Orthodontics. Department of Oral Pathology and Microbiology. Department of Pedodontics and Preventive Dentistry. Department of Periodontology. Department of Public Health Dentistry. Faculty of Architecture. Architecture Lobby. Classroom cum studio. Workshop. Seminar hall. B.Arc, First Year Studio. B.Arc, Computer Studio. M.Arc, Computer Studio. B.Arc, Studio. Photography Lab. Faculty of Allied Health Sciences. Faculty of Pharmacy. Faculty of Nursing. Good ambience of classroom and labs with highly qualified doctors for teaching. Faculty of Physiotherapy. Smart Classroom. Electrotherapy Lab. Exercise Therapy. Faculty of Law. Faculty of Humanities and Sciences. Physics Lab, Chemistry Lab, Smart Room, Computer Science, Computer Lab 1, Computer Lab 2, Computer Applications, Computer Graphics and Multimedia, Visual Communication, Character Modeling, Chroma Studio, Audio Studio, Graphics and Multimedia Lab, Faculty of Arts and Commerce,